appeal in the matter of Akbars Restaurant, Middlesbrough Limited as Secretary of State for the Home Department.
Good morning, Your Lordships. I appeal on behalf of the appellant, Fred, and his junior appeal on behalf of the respondent.
Yes.
Before we start, I don't know if the court has been notified, but I've had some difficulty in relation to my computer decided not to work this morning.
Oh, no,
so on the train down the laptop, suddenly I opened it up to just go over the file and the screen is blank and it will not turn itself back on.
What are you? Are you without papers?
Thankfully, junior counsel for the respondent has provided me the bundle, a copy of the bundle. So yes, a hard copy. I should be able to proceed.
All right.
But I just wanted to make you aware if I'm a bit slower going between the pages, that is why.
Understood.
I'm grateful for that. So in terms of just housekeeping then, you should have a bundle which comprises of 165 pages.
Yes.
There should be an authorities bundle which has been prepared by the respondents.
Yes.
And I think late yesterday I did send an email through to your clerk with it was a further document. It was the cover letter that accompanied the objection notice.
Yes, we got the cover letter. I couldn't open the PDF attachments, but I think those are the notice of objection which we've got. Now, as you will know, we received a supplementary skeleton on the 29th of October. Do you have anything to say about that in principle?
The only thing is what I've already written into the court with, which is that this matter was to be reviewed back in February of this year. And I contacted the respondents to conduct that review, provided my review and invited comment, and nothing was done for the next 6, 7, 8 months that proceeded thereafter. Everything that's happened from the respondent's side, including the supplementary argument, is something which, as you rightly pointed out, Your Lord, is happened right at the end of October.
Yeah.
It does take me by surprise in some respects, but I don't obviously disagree with the principles contained in the cases there. It's something I think which is fairly trite now in terms of how we interpret statutory legislation from that perspective. There is only one further comment I would make, is that there is a case that I would want to refer to called Massan versus the Secretary of State for the Home Department. That's 2011, England Wales Court of Appeal, Civil Division, and I believe it's 686. That case was dealt with obviously in this court, and it concerned the interpretation, the statutory interpretation of this particular legislation and how we interpret time. So that being the 28 days in which someone may appeal against a decision following an objection, and the decision effectively states that because there is no provision made within the legislation, there is no extension of time to be had. It refers to an earlier case dealt with by that. I believe Your Lord is familiar with it.
I'm not familiar with this case, but
with the principle,
I'm familiar with the principle.
Yes.
That if there's a statutory time limit, there's a statutory time limit.
There is. Quite. The only reason that I was going to refer to it is because I've seen the supplementary skeleton argument where my learned friend says that because no reference has been made within the legislation of what happens in circumstances where there may be a breach, effectively that is supportive of their position. It doesn't mean that the notice would then be deemed
Well, I mean,
effective.
are you ready to refer to this Massan case or not?
I'm ready to refer to it insofar as I would like to rely upon it. Unfortunately, the document is sat on my laptop, which I can't access at the moment. My learned friend has very kindly managed to obtain a copy of the decision. Perhaps it could be handed up,
Right.
and then we can look at that if need be.
All right. Well, Mr. Malik, two things. First of all, the judge below did not decide the point on the Sonergy line of authorities. So it seems to us you need a respondent's notice to raise the point. And it seems to us you are out of time. And there doesn't seem to be an application for an extension of time in which to file a respondent's notice. The service of supplementary skeleton arguments is dealt with by Practice Direction 52C, paragraph 32, which you haven't complied with either. So why should we permit you to rely on this additional argument?
Yes, Lord, it's not that I'm seeking to dodge these valid questions, Subject to any observations, it is proposed that Ms. Heron will deal with the application to rely on the supplementary skeleton argument. So unless my lords have any objection, may I ask Ms. Heron to
Of
address
course.
the court as to the application?
Yes.
Yes, sir.
Yes, Miss Aaron, you've heard what I've said.
I'm grateful. My lord, can I first inquire as to the reason why you say that paragraph 32 of Practice Direction 52C is not being complied with? As far as we note, the content of that paragraph states that an application for permission to rely on a supplementary skeleton argument should be made if it is necessary, and it should explain why the skeleton
Yes.
argument could not have been lodged.
Have we got that application and explanation? I'm
Yes.
not aware of it in the bundle.
It wasn't included in the bundle. I'm afraid the bundle was prepared and filed with the court before that application was produced. That application was sent to the court, I believe, and dealt with, well, perhaps not dealt with, but it was sent to the court. And the appellant was asked to make submissions in response to that, to the court. I believe it might have been Lord Justice Zacaroli. No. There were submissions that were asked of the appellant in response to that application. It wasn't included in the hearing bundle because that was produced earlier, but if I can assist the court, I can email a copy of that application to your clerk if that may be of assistance. Alternatively, I can explain what that application...
Well, why don't you explain it to start with, and
Of
if we
course.
need to see the document, we'll ask for it.
Thank you. The
So
application
when was the application made?
was filed and served on the 22nd of October.
22nd?
Yes.
Well, the skeleton we've got is dated the 29th.
That is the replacement supplementary skeleton
Oh, I see.
argument. It simply refers to the page references in the hearing bundle and the authorities bundle. But the original skeleton argument was filed on the 22nd.
22nd?
Yes.
Right.
The application is as follows. The court has to consider two things, as you've already noted. The first issue is whether it is necessary to rely on this supplementary skeleton argument. And we say it is necessary for the court to consider this supplementary skeleton argument and the authorities cited therein, because those authorities address directly the issue which the court has to consider. And I appreciate the point being made in terms of the issue not being determined by His Honour Judge Gargan. However, the appellant's explicit argument in the skeleton argument is that the penalty notice is invalid because it is defective. No authority was provided to the court in support of that argument as to explain why, if the penalty notice is defective, it means that the penalty notice is also invalid. So we say that this issue was something which the court was always going to have to consider in this appeal before it could determine whether the appellant remains liable under the penalty notice or not. In addition to that, we say it is necessary for the court to consider that line of authorities in order to make sure that the decision reached by this court is one that takes into account all relevant legal principles. In this particular point, whether the line of authorities is necessary, we note that the appellant does not dispute that contention. It also does not dispute the principles enunciated within the line of authority that has been presented in the supplementary skeleton argument. In fact, to the contrary.
You make that out. There's no formal documents.
No.
There's no respondent's notice. So I'm a bit puzzled as to how it could be necessary for us to decide it when the respondent hasn't bothered to put in a respondent's notice. And then if there was a response to the respondent's notice, then that's where the appellant would set out its objections. But instead there's a very late skeleton argument and nothing from the appellant. So I don't understand how you say the appellant doesn't dispute any of it.
There was, the reason why I make that submission, my lord, is that the appellant's counsel wrote to the court on the 29th of October to say that they do not dispute the principles enunciated in the authorities cited in the supplementary skeleton argument.
But why hasn't the Secretary of State complied with the rules?
That is my next point. There are two alternative positions. If I have any credit with the court, I would like to refer your lordships to the skeleton argument, the original skeleton argument that was filed in January of this year.
Right. That's the original, not the replacement.
The original, not the replacement. Oh, it could be the replacement as well.
Right.
The replacement
Yeah,
certainly
right.
includes references. If I can take your lordships to paragraph 4.8,
4.8.
that's at page 8.
4.8, did you say?
Yes, my lord.
Yeah,
It starts with the appellant's interpretation must also be wrong,
Yes.
if you have that.
I have that.
I'll summarize what that paragraph says, although not in as many words. It makes the same point which the supplementary skeleton argument makes, which is that if a penalty notice gives a wrong reason, that in itself does not mean that liability to the penalty does not continue. It can continue if, at the rehearing before the county court, there is evidence to show that liability could have attached for a different reason.
That seems to me, with respect, to be an entirely different point.
I appreciate that. The substance of the point, we would say, was the same as the line of authority, which is that a defect doesn't necessarily render liability under the penalty a nullity. If the court is not satisfied that that is the essence of that paragraph in the skeleton argument, then the alternative position is to state that this point was something that was raised by the appellant in their skeleton argument, although implicitly their argument is that the penalty notice is defective and as a result it is invalid. That argument was never made explicitly, no authority was put forward, and at the time when this skeleton argument was being produced, admittedly, I was not aware of the line of authorities which are currently being cited. And so the reason why the supplementary skeleton argument was produced at a later date was in order to bring to the court's attention the line of authority that the respondent has discovered since. I'm afraid that is the reason why we have not complied with the rules and included that argument in a respondent's notice as the rules require.
Well, even now there's no application out of time to file a respondent's notice.
My lord, that is correct. The position that the respondent took based on paragraph 32 of the practice direction was that such an application would not be necessary in circumstances in which the rules don't require that application to be made.
Don't understand that at the moment. The judge said your notice was perfectly all right, nothing wrong with it. You now want to say, well, if he was wrong about that, it doesn't matter. Now, that's asking us to uphold the judge's decision on additional grounds, isn't it?
Yes, my lord.
Therefore, respondent's notice required.
I accept that. I assume in the ordinary course of action, we would make an application for relief from sanction, given that a respondent's notice was not produced in time.
Well, then we'd have to apply the Denton criteria, wouldn't we?
We would, and if I have your permission, I would like to address you on that.
Well, where's the application to file a respondent's notice?
I would have to ask the court to be amenable to consider the application made orally as opposed to in writing, because such a written application was not produced.
That wouldn't be in accordance with the rules either.
My lord,
I mean, just because this is public law doesn't mean that the civil procedure rules don't apply.
absolutely. That wasn't my submission at all. Apologies if that was what I suggested. But the court will have very wide powers as to how it can deal with a case, including an application made orally as opposed to in writing. And I would invite the court to exercise its discretion to hear that application orally, because there are good reasons why this supplementary skeleton argument should be considered in this appeal.
Yeah, all right. No, I'm afraid we're against you, Miss Zarin. There is no application, even out of time, to file a respondent's notice. The point has arisen very late. Mr. Mohammed is to some extent hampered because he hasn't got the case he wanted to refer to. This is not a reason which the judge gave for dismissing the appeal, and a respondent's notice is required. The rules apply to the Secretary of State as much as to any other litigant, and those rules have not been complied with. It would be a very, very late application, and so we refuse to permit reliance on the supplementary skeleton argument.
I'm grateful.
Yes, Mr. Mohammed.
I'm grateful. Are we then in a position to proceed now?
Yes.
Yes.
No, we have a very short point.
We have a very short point indeed. Well, that's absolutely correct. In effect, what the court is concerned with today is the reading of section 15 of the Immigration, Asylum and Nationality Act of 2006. The particular parts which are of importance to us today is going to be section 15.1 of the Act and section 15.6a.
15.6a, did you say?
Yes. Even though I don't have a authorities bundle, but I'm familiar with the legislation, so I'm happy to deal with it as we go.
Yes.
So, in relation
Section 15.3 might have something to do with it as well.
to give me a lot, I'll have to obtain a copy of it, or perhaps you could tell me what that is.
Oh, I see. It says that an employer is excused from paying a penalty if he show that he complied with any prescribed requirements in relation to the employment. And there are regulations telling the employer exactly what he's got to do. They're the Immigration Restrictions on Employment Order 2007, I think.
Okay, effectively the statutory defence is what you're referring to, yes. It wasn't something that I covered because obviously my argument focuses strictly on the penalty notice itself and whether that complies with the legislation and what was required by Parliament in a penalty notice. If I could perhaps start with the other way round in this instance, section 15.6a first.
Yes.
So that would say that a penalty notice must state why the Secretary of State thinks the employer is liable to the penalty. It's not a difficult thing to comply with. It's something which is very obvious. You say, we have issued you with a civil penalty notice because, and then whatever that reason is. The reasons that you can refer to are identified in section 15.1 of the 2006 Act, so deal with that second. It says it is contrary to this section to employ an adult subject to immigration control if A, he has not been granted leave to enter or remain in the UK, or B, his leave to enter or remain in the UK is invalid, cease to have effect, or is subject to a condition preventing him from accepting employment. Turning very briefly now to look at the penalty notice itself. I believe it appears at page 109 of the bundle, but mine's not paginated, so forgive me if that's not the right page.
Yeah, we've got that at 109, yes.
So it says in the first red-headed box there, it says you are liable for a civil penalty. Details there, we encountered a suspected breach of section 15 at your business on the 15th of January 23. You considered the information evidence in your case and concluded you have breached section 15 of the Immigration, Asylum and Nationality Act 2006 by employing an adult subject to immigration control who has, and this is the key bit that we now look at.
This just repeats the statute.
Section 15.1, yes. And then it lists all of the reasons why somebody could be issued with a civil penalty notice.
Yes.
Now, Going back to the skeleton argument in this matter, where I've identified these are all mutually exclusive reasons. They can't exist at the same time. Either somebody is in the UK with no leave, or somebody is in the UK who had leave, but that leave has subsequently ceased to have effect, might have expired, been curtailed, or you have leave to remain, but you are in breach of a condition concerning your employment. Now, in my respectful submission, the penalty notice, which is given to a lay member of the public, is not going to understand that. They're going to say, what is the person encountered? Are they lawfully in the UK? Have they had leave which ceased to have effect? Do they have leave, but they've breached the condition relating to their employment? It's not clear. It could be any one of those three reasons. And what we've already looked at when we considered 15.6a of the 2006 Act is that it said we need to set out the reason why, not the reasons, the reason why he thinks the employer is liable to the civil penalty.
But it doesn't say reason or reasons, does it? It just says state why.
Sorry, forgive me, my lord, yes. It says state why, but it envisaged, in my respectful submission, reference to section 15.1, and it envisaged that you would pick one of those reasons, realising that they are mutually exclusive from one another. They can't exist at the same time. It has to be one of them. It can't be all of them. Now, when I say that it can't be all of them and it has to be one of them, what he said, because those reasons are mutually exclusive from one another. The other reason why it's important is because the records of immigration are maintained by the Secretary of State through the immigration rules, previously through the European regulations. They would allow people to enter the UK and remain. Any person that they encounter biometric fingerprint scan or however they're doing it now, they would know what that person's immigration history is. They know when that person came into the UK, they know any applications that have been made, they know any extension applications, if they subsequently become free of immigration control, they know all of that. There is simply no good reason, in my respectful submission, for them to play this game of, if I can put it bluntly, silly buggers with the employers and say, well, it's one of these reasons, but you will work out which one it is, knowing fine well what the actual reason is. It is
Those submissions focus on the first part of the notice, as I understand it, the paragraph under you are liable for a civil penalty, because you say they're mutually exclusive rather than being all of these options. One understands that. Does it follow from that that on your case, it doesn't matter what the notice says thereafter?
No, my lord, I think that there is further supplementary information which is given within the notice itself.
So as a matter of principle, even if you were right in your criticisms of the first paragraph, the notice could still be valid depending on what comes next.
Well, what they do with these penalties, I want to say yes, and for this reason, my lord. The reason why is because they provide what's called a statement of case with the penalty notice, and that provides further information about the investigation in a very summary form, but it sets out the person encountered, what that person may have said in an interview, and then says something along the lines of that they had no right to work.
Yeah, I'm just testing the proposition, your case, your submissions so far have all dealt with that first paragraph. One understands that submission. What I'm testing is the extent to which, on your case, the notice can still be saved by something that comes later in the notice or in the statement of case.
Well, I think the reason why I say that in theory it could is because if
So
they,
you do.
well, it could. I'm not saying it does. It depends.
No,
on the,
I'm just testing it as a matter
Yes.
of principle. It could be.
it
It could be saved, notwithstanding the points you make about the first paragraph, it could be saved by the rest of the notice.
My lord, let me put it this way. My primary submission is one, it cannot be saved by what's contained in the rest. My alternative submission to that is that if it can,
So your primary submission is it cannot.
it cannot.
So that the first paragraph is fatal.
Is
So
fatal.
the template part, which one assumes is a template part, is fatal to the rest.
Yes,
That's your first submission.
yes.
Um,
But in the
just
alt-
make a note.
oh, sorry, man.
Yeah, and then if you're wrong about that,
Yes.
it can then as a matter of principle it can be saved.
It may be able to be said depending on the information that is then contained with the supplementary information provided with the civil penalty notice. If they were,
So on that basis, it is this first submission is your principal submission.
in my principal submission, yes, my lord, yes. Sorry.
Thank you.
Now, picking up on the point you were making there, my lord, about
Can I just make sure I've understood this? You tell my lord that because in the box headed you are liable for a civil penalty, the notice simply sets out the section. That's the end of it. It's wrong. It's invalid because that's what it does. But what about the box which says penalty reason? And what about the box saying evidence of breaches of the law, saying the attached statement of case sets out the reasons for the breach?
yeah, that's why I said in the alternative, I'm wrong about that. I accept that there is an argument to be had that further information, so the supplementary information that is provided with the notice, if it was, if I can be blunt, more forthright and honest, just saying, look, these are the records, this is the situation of that particular person, their leave has ceased to have effect. If you were to be that forthright, then one could say that there is no ambiguity about which reason that they are pursuing. But this penalty notice does not do that. What it does is say that you have no right to work, but that would apply as a consequence to any of the reasons identified in 15.1 of the 2006 Act. It's not a reason, it's a consequence of the reason. If we could perhaps move to page 113 of the bundle now. So this is the statement of case which accompanies the penalty notice. I think the important part for what we're going to be concerned with today is contained in paragraph 4 and 5 of that document. There the respondent sets out what employment is defined as. And she goes on the second sentence to state the evidence we hold demonstrate that Naresh Beldi was employed by you under contract of service as defined under section 25B. She then says, please be advised that the Home Office records show that Naresh Beldi does not have the right to work in the UK. Again, not providing anything cogent which could then identify the reason, rather just simply stating as a matter of fact they have no right to work in the UK.
Is there anywhere in section 15 or anywhere else in this part of the Act which specifies the Secretary of State must identify the employee or alleged employee, identify what job they were supposed to be doing or alleged to be doing?
Certainly not my understanding, my lord, no.
So that would fall within why the Secretary of State thinks that the employer is liable to a penalty, isn't it? Because there's nowhere else required. We have to be within that subsection.
I think it's the fact that we have to kind of cross-reference section 15.6 with section 15.1a. The reason is provided for within the statute itself. You have to pick one of them, in my respectful submission. And that is why you believe that the employer is liable for the penalty.
Well, surely it's because the Secretary of State thinks there's a person who they allege is being employed by the employer, doing a particular job on particular dates they see them doing it. Isn't that what's encompassed within why the Secretary of State thinks the employer is liable to the penalty?
Well, in part perhaps, my lord, because of course they have dealt with this section which we've looked at where they talk about employment and what constitutes employment. But that is only one side of the coin. There is another part of it where we need to look at the immigration, because obviously without that person being subject to immigration control, and that is a wholly different situation and to employment, without identifying what the reason is why they're subject to immigration control, you then are not in a position to issue the civil penalty. It's key. It's a central part of the civil penalty notice in my respectful submission that you must identify why this person is not allowed to work. Simply saying they're not allowed to work, as I've already said, that's the consequence of one of the reasons in section 15(1) of the 2006 Act. That's not very helpful in my respectful submission. To simply pick the relevant section, so A, B or C, whichever one you want, and then provide the immigration documents or at least a summary of what the records say, is what would then assist an employer to understand why the penalty notice has been issued. Identifying the person and saying what work they were doing, and that really goes to the employment side of it in my respectful submission. It doesn't go to the immigration aspect of it. And obviously both parts need to be present in order to issue the civil penalty itself.
Now, you've emphasised the fact that this notice is given to a layperson and the difficulties that a layperson might have in understanding. Isn't it the simplest thing in the world for the layperson to be told this employee has no right to work, rather than saying he had a condition attached to his visa which is broken or something like that?
You say he's got no right to work. Well, it doesn't identify I know exactly what you mean, but the respondent has adopted both parts of that, if you see what I mean. So in the notice, they've referenced the Act itself, and then they've tried to simplify it further by saying no right to work.
Yes, well, isn't that's what the employer needs to know? You're employing somebody who's got no right to work in the UK.
You should say perhaps why that is.
Why?
Why? Because the circumstances are incredibly important to determine if the decision has been made correctly or not. So in this particular case, Naresh Veldi was deemed to be somebody who leave ceased to have effect. And what actually happened in his case, and we only found out on the day of trial because that's when the evidence was produced, what actually happened in his particular case was that he made an application for an extension in time. So he had a valid visa, he made an application to extend that visa. During the application stage, he applied for a fee waiver. A request was made for information to determine whether he satisfies the fee waiver test or not. He failed to provide that information, allegedly, and then the respondent made a decision saying that, well, this application which you have made in time is now invalid because there is no fee to accompany the application, which is a mandatory requirement under the immigration rules in terms of a valid application. An employer would never know any of that. I mean, it's so far out there. That's why it's so incredibly important to identify the reasons. An employer, when you look at the information within the statement of case, it says when they interviewed a person on behalf of the employer, he said, the guy showed me his application, he's made an application to extend his leave to remain. So to the layperson, that is all that he would have needed to do. As long as he's got a valid visa, he's extended that, it continues under Section 3C of the 1970. That's correct, that's right. What could never have been foreseen is this fee waiver business and the fact that he then failed to provide information and that it would then be deemed an invalid application. It's just not foreseeable at all. So in order to be able to challenge these penalty notices, one needs to understand the reason why they've been made in greater detail than simply saying, well, you've got no right to work. Because what came out at the hearing before His Honour Judge Gargan is that the date that even the Secretary of State believes that Naresh Veldi's leave expired isn't in fact the correct date. And that is because the Secretary of State operates a policy whereby when somebody has a fee waiver application and that is rejected, they have a period of time, a grace period, where they can make the application and pay for that application. But these matters were not taken into account. And this is just one example, of course. There could be other examples. There is I don't know if I can go as far as that, Lord, but there's a case standing behind this case as we speak, which I'm dealing with, and the argument is that the person has no right to work. Again, that's what the penalty notice is saying, but he has a valid visa, it has the ability to work for 20 hours during term time, and then non-term time, full-time hours. To my mind, it's clearly a mistake, but the point is, without that information, you don't even know why they've issued the penalty notice. From the
Yeah.
immigration perspective, that is. My Lord, if I could move to now page 116 of the bundle. This is the objection notice.
Yes.
Unfortunately, the email that was sent over yesterday, which had the cover letter which accompanied this document,
Yes.
you said the PDF would not open. The PDF, the cover letter, is actually far more detailed than simply saying, please find attached the objection notice. The cover letter, in fact, goes into greater detail concerning the reason why the penalty notice has been issued. And it said when you're saying no right to work, presumably, given that the guy's made an application in time, he has lawful leave to remain in the UK. That is not being challenged. What presumably is being challenged is whether he has got a condition preventing him from accepting the employment that he had done at the time of the investigation. That's what the cover letter explains in it, and it requests further information from the Secretary of State. It says provide as much information as possible so that they can consider the position as to whether he wishes to appeal this later on. So it is not clear, in my respectful submission, to actually anybody at this stage, if it be the lay employer, if it be the representative appointed, there is not sufficient information to make clear exactly why the penalty notice has been issued. Needless to say, the Secretary of State did not respond to that with further information and provide a summary of the immigration records which she holds and would have had access to. She didn't even go as far as to say the leave has ceased to have effect. Simply says, I'm looking at page 119 of the bundle now, in the determination of the penalty notice. Second paragraph. Home Office systems confirm that Naresh Veldi had no right to work in the UK at the time of employment with Akbars Restaurant. That takes it no further forward than it was within the original penalty notice. It fails to deal with the points made in the objection, seeking further information, seeking to understand the nature, the reason, the basis upon which the penalty notice was issued in the first instance.
But how does this affect the validity or otherwise of the original notice?
Yes, Lord. The reason why it affects it is because in my respectful submission, this is giving you further information which sits around the matter. So when we look at whether this is going to say the notice is now invalid or not, depending how you decide the matter, we want to look at the effect of that notice. How did it, what effect is it causing on the employer? Is he able to challenge this? Does it make him vulnerable in this situation? Because you can't simply say it's invalid because it's enough just to simply say, well, the penalty notice is the effect. There needs to be something more beyond that. There needs to be a disadvantage created to the employer. Some form of prejudice, if I can put it that way.
Had the employer complied with the prescribed requirements, which it hadn't done in this case, but had it done so, would it have discovered that this employee's right to work had expired, or there was no right to work?
Because of the very unusual circumstances of this case, my lord.
It would have been excused a penalty in those circumstances.
Well, no, they wouldn't be excused the penalty. The reason why is because they would have to do the check at the time of when he was employed. So that's the passport, biometric residence card, national insurance number. If they'd done that at the time, they would then say, right, you need to log a date of when that period expires, so you're covered for a period of time. I believe the updated policy would say, if there is a pending application, you are covered for 6 months. That wasn't the policy at the time. So it's a very grey area, if I can put it that way to you. What it means is that once they come in and they realise that you've made an application, fine, we're with you so far. But the moment you applied for the fee waiver and it was rejected, and they failed to then make a fresh application by making the payment, at that point it becomes deemed unlawful. His leave ceases to have effect. At that, how would the employer know any of that?
That's why I'm asking. But what they have to do is prescribe in the regulations. Had they done all of that, you say they still wouldn't have found out about the non-payment of the fee. But had they done all of that, why wouldn't that have given them an excuse under the section?
It wouldn't have given them the excuse because the person was still unlawful at the point of the investigation.
Sorry, I'm not following that.
Oh, sorry. He would be in a situation where his leave, because the application for extension would have then been deemed invalid because he obviously hasn't made payment. Either one, sorry, he hasn't been granted his fee waiver, or two, he hasn't then made a paid application. That application then falls away. So therefore, he doesn't have valid
That
leave.
doesn't affect the point. The point is that if the employer does what the regulations say he ought to do, then even if that does not reveal that the worker has no right to work, the employer is nevertheless excused.
My lord, that's, I mean,
If section 15.1 doesn't apply anyway, then there's no question of a penalty. 15.3 applies where 15.1 does apply, but the employer has complied with the regulations, which your client didn't do.
I
So
agree.
my lord is quite right, isn't he, that if you'd used the Home Office Employer Checking Service or whatever it is, and that had shown that Mr. Veldy was entitled to work, when in fact he wasn't because the fee remission application had gone by the board, then your client would have had an excuse.
My lord, I'm still going to maintain the position that he wouldn't have an excuse.
Right.
And obviously the respondent can obviously set out their position on this. I certainly believe it's going to be the same answer. Because at the time of the investigation, they're going to say the person had no valid leave. Yes, you've done your checks, but because you don't have a visa which covers that period and beyond, you have a limited period of time for which you can employ that person. And that is, at that point, at your own risk. Now, it's 6 months. But one must not, forgive me my lords because I'm backtracking slightly here, one mustn't misunderstand the basis upon which the appellants challenged this penalty notice. They never once said, we've undertaken our checks.
No.
They've never said, they've simply said, look, the guy was meant to bring the documents, he didn't. He showed me the application on his phone, and we have the letter of the application, but that's all we have, which is insufficient. We know that. But what they did when they were challenging it was to understand the basis upon which the penalty notice has been given, because it would seem, if he has a pending application, he had statutory leave to remain at the time of the investigation, as opposed to someone the respondent then says is unlawfully in the UK because their leave has ceased to have effect. And accepting that they haven't done their checks in the way that they should have done, my lords will note that they paid the penalty notice up front without prejudice. Because they're not saying, for example, that they're not liable or anything like that. They're just simply saying that we don't have the information in order to assess. And again, that kind of makes the point about this entire case.
Yeah.
It's the theme of this case is that they just don't know. And when they've asked for the information, it will not be provided. Which then leads us on to the next part, which is, okay, well, if the objection is not upheld and the original penalty notice is then maintained, what's your next course of action? Well, your next course of action is you file an appeal under section 17 of the 2006 regulations. That, in my respectful submission, creates further problems still. Because when you appeal that decision, what are you actually appealing? Are you appealing the decision that the alleged illegal worker has no leave to remain in the UK? Are you appealing the decision that his leave has ceased to have effect? Are you appealing the decision that actually he has leave, but he has a condition preventing him from accepting the employment? Which one is it? And we are dealing with an appeal of a decision, not an appeal of decisions, if I can put it that way.
Yeah.
Otherwise, we make a mockery of the appeal system itself. And that is what has been created here. And without offering damage to his Honour Judge Gargan, who dealt with the matter in first instance, perhaps something he didn't appreciate when he was considering the argument that was placed before him. So one has to now look at the question and say, so what are you actually appealing? Yes, the penalty, I understand that, but which reason, on which ground is it that you're appealing? And when I say that, I mean against A, B or C, as stipulated within the penalty notice.
Well, on that, Mr. Mohammed, can you help me? Obviously, you had the penalty notice, and you appealed the penalty notice, which is page 97. It's the appellant's notice.
Yeah.
Dated the 12th of May. And it's not a very illuminating document on its own. Page 100 says, what are you appealing against? The decision to impose a civil penalty of £15,000 against the appellant. But then over the page, it says, and the box is ticked, I confirm that the arguments in support of the grounds are set out on a separate sheet. Do we have that? Speaking for myself, I was quite interested to know how you were putting it, given that this was May.
Yes, my learned friend, my junior, made a very important observation that it was missing, and she's included it. I believe the document's been passed.
Not yet.
Not yet, but the document is available to the court. Forgive me, my lord, because it is an important document and it's not there.
Right, well, if Ms Sarin has got the documents available, I think we'd better have a look at them.
Yes.
You've got this too, have you, Mr Mohammed?
Yes, my lord, I do have the document that were very helpfully provided by the Response Junior Counsel before we started. Mine was split up into tabs A, B and C.
Yes, I'm not quite sure what we've been given. We've got an information request.
Let's see.
We've got a skeleton argument in the county court.
I think it's C, is it? Detailed grounds of appeal. Certainly that would fit the date, because that's the 10th of May.
Yes. Sorry, forgive me. I think there's been some. Yes, I think there's been some labelling on my documents here because it's identified as B, but I think the respondent is saying it's tab C. Is that correct? It should be a detailed ground.
In this little file, tab C, page 13,
Yes.
running to page 16, is your detailed grounds of appeal,
Yes.
which must have been the document attached, the document I was asking for, because the dates tab, because as I pointed out, the original notice of appeal is the 12th of May. And so the point in the grounds of appeal is that the illegal worker had applied for further leave to remain. That was ground one.
Yes. So if we look at page 14, obviously it gives the detail of that ground.
Yes.
And you can see from what is contained there under paragraphs 8 and 9, it is believed when they're saying no right to work, they mean that there's a condition preventing them from taking employment.
The short point is that this document doesn't suggest that the penalty notice was invalid or not understood.
If we look at page 15 of the of that bundle, please.
15.
Yes, and we go from paragraph 13 onwards, between 13 and 15. Sets out there that during the statutory objection phase, the appellant requested evidence which demonstrates the alleged legal worker had no right to work in the UK. making it abundantly clear that the provision of such information is incredibly important, as it will form the basis of whether an appeal will be lodged if the statutory objection is dismissed.
But it doesn't say that the original penalty notice was invalid.
No, I accept that it doesn't raise that point, no.
Sorry, that was what I was putting to you.
Forgive me, my lord, no, it does not.
So that's why that Judge Gargan said that you didn't really dispute that the notice was valid. Is that right? I think he says that, and find it. He says that at page 53 of our court manual. He sets out what Ms. Saran was arguing, that it satisfies a requirement because the notice says there's a breach of section 15 for one or more of the reasons, and that's enough. And the judge says at paragraph 28 that you don't seriously challenge that argument. And your case there was based on an election to proceed on the basis of one particular subparagraph.
What I would observe is that it says...
And that seems to be consistent with your notice of appeal. That
Yes,
you
my
didn't
lord.
challenge the validity of the civil penalty notice.
Well, my lord, what I would say is that it says, in my judgment, sorry, Mr. Mohammed does not, in my judgment, seriously challenge that argument. So that's not, and obviously you can see from my grounds of appeal that I do take issue with the way that he's determined that.
Yes, well, you do now, yes.
Yeah, well, I mean, I did at the time as well. As I said, I don't think he understood the argument that was necessarily before him, because he seems to think it was, I mean, he thinks that you can pivot from one to the other, irrespective of being notified which particular ground it's being run under. I will come to that in a moment. That's where we're heading.
Anyway, when the appeal was launched, you weren't challenging the validity of the notice.
At that stage, no. I think the best I can put it, my lord, is that I was requesting information to understand the basis upon which the penalty notice was issued in the first instance. Forgive me, my lord, I'm just checking the skeleton argument that was before the circuit judge.
Yeah, the skeleton argument does seem to take issue with the form
Yes.
of the notice.
That's August.
It's paragraph 10 of your skeleton, page 59.
Yes, paragraph 10 does highlight it is. Yes, the 15th of August 23, yes. And that's why I say I'm not sure that he understood the argument that's necessarily before him, because what he's saying is that I don't seriously challenge it when it quite clearly does within the skeleton argument itself.
Yeah.
So having filed the appeal, and in the grounds of appeal highlighting that further information is required, and even setting out as much as that the appeal might be compromised at a very early stage if we just have this information. No information was forthcoming. So in those circumstances, correspondence was sent to the respondent asking them to clarify the basis upon which the penalty notice was being pursued. If you bear with me. I think it's 122 onwards. Forgive me, my lords, I'm just trying to find the email exchange between the caseworker who confirmed the position. I think it's on page 127 of the bundle.
Page
127.
127.
Having not being able to identify why the penalty notice is being issued. Trying to understand, is it because the person has no leave? Is it ceased to have effect? Is there a condition? We believe it's the condition argument as set out in the grounds. And there was no respondent's notice at that stage either to the appellants that are setting out that position. But it says here, page 127, dear Mr. Mohammed, we've now taken instructions from the Secretary of State for the Home Department position to stand by the penalty notice issued pursuant to section 15(1)(b)(3) of the Immigration, Asylum and Nationality Act of 2006. Now that particular section relates to a person who has leave but has a condition preventing them from accepting employment. So in absolute, unequivocal terms, on the 10th of July, well before the appeal hearing date, the respondent finally confirmed the basis upon which it issued that penalty notice.
But he's only repeating that section from your earlier email.
Yes, I accept that, but he could quite easily have said it's...
He could have done.
Oh, sorry, yes,
I
my
mean,
lord, yes.
you say unqualified, to be fair. I mean, you are the person that identified B3 and he parrots it in his reply.
Yes. So he says B3.
He then says the position is set out in the respondent's witness statement. Now, I believe it wasn't served at that point. It was served 11 days later. And when it was served, it made it clear that it was under B, not B2, not B3.
Yeah, I mean, that's the point that I then take with him afterwards, is that having seen your evidence, it seems quite clear that you're looking under B2, namely someone whose leave has ceased to have effect, as opposed to B3, someone who has leave but the condition preventing the employment. And the response that we received to that is that actually, no, both of them apply. B2 and B3.
We don't have the evidence, do we? The respondent's witness statement is not in the bundle, I think.
The witness statement is not in the bundle. If it is of assistance at this stage, my lords, what I can confirm is the evidence was a witness statement which set out why they believed that they issued that penalty notice. The relevant documents, the pertinent documents which allowed them to evidence the point they were making, were not served until the day of the hearing itself, and a relief from sanctions application sent to me at 2 AM in the morning, which His Honour Judge Gargan granted, and he accepted when making that decision that without this evidence the Secretary of State could not possibly succeed in this case.
Now, I'm not quite understanding what this has got to do with the question whether at the time it was served the civil penalty notice was or wasn't valid.
Sorry, my lord. The reason why is because
Your main point, as I understand it, is that it's just a piece of waste paper, this notice. It didn't do what the statute requires, and therefore it's invalid. So what happens afterwards can't have a bearing on that, can it?
No,
Or does it?
well, I guess the point that I'm trying to get across the court, and forgive me, I'm not doing it very well, is that there are so many interpretations of this. One from the way the layperson looks at it, the representative looks at it, the Secretary of State itself, whose penalty notice it is, the way that they look at it, they can't even identify the reason why this penalty notice is being pursued. It keeps evolving, if I can put it that way, and that's how it was during the case. And that itself demonstrates that there is no clarity to the penalty notice. And when we have regard for what that penalty notice is, the Secretary of State is given the power to issue penalty notices for a minimum £10,000–15,000. It's a significant amount of money, and then telling people that you pay them within 28 days, and if you don't, well, that has the effect of a judgment. So what's contained in the notice is of paramount importance. But when the Secretary of State themselves don't understand the penalty notice, because in the litigation they're saying it's pursued under B3, and then later on say, actually no, B3 and B2. The fact that that's irrational is not by the by. The point is they don't even know.
Yeah.
So how is the employer going to know? Do you need me at all, my lords, to deal with the irrational position point? It seems quite clear.
Deal with the what point?
But the irrational position that was adopted by the respondent, saying that it was pursued under B2 ceased to have effect, or B3, sorry, and B3.
But again, that doesn't affect the notice.
No,
That's
no, no, no.
a point in correspondence with
Yeah.
a junior official at the Home Office.
Yes, makes sense. So I believe, my lords, that may well be my submissions on the matter.
All right,
I'm
thank you
grateful.
very much.
Thank you.
Thank you, Mr. Mohammed. Yes, Mr. Malik.
My lords, Miller and Friends submission, if I've understood it correctly, is that the notice issued to the appellant did not comply with the condition in section 15, subsection 6 of the 2006 Act. And for that reason, the notice was invalid or unlawful, and the judge below should have allowed the appeal. There are, in my respectful submission, three difficulties with the submission that Miller and Friend makes. First, it is inconsistent with the natural and ordinary meaning of the words used in section 15, subsection 6 of the 2006 Act.
Yeah.
Second, it is inconsistent with the legislative scheme read as a whole. And third, it is inconsistent with the authority. So may I make very brief submissions on the 3 points in turn. Starting with the text of the relevant legislation, Miller and Friend took you to section 15 of the 2006 Act. You have that in the authorities bundle behind tab 1, page 4. On its natural and ordinary reading, subsection 6 simply requires the Secretary of State to state why, in her view, there should be a notice. Nothing more than that. The provision does not say that the notice should specify the statutory grounds on which the Secretary of State relies upon, or precisely which subsection, which limb of subsection 1 was breached. Now, it is surely desirable for the notice to provide as much detail as possible, but the requirement in law is nothing more than to state why the Secretary of State thinks that there should be a notice.
So you say it's enough for the notice to say, the reason why we're imposing this penalty is that you are employing somebody who's got no right to work in the UK.
Yes. So there is, in my respective submission, no need to read this provision in an overly technical manner. You look at, in my respective submission, the notice as a document read as a whole. It's quite clear in my submission that what the Secretary of State was saying in that notice was that she considered that the employer had breached section 15, 1 of the 2006 Act, because the employee in question had no right to work. As a matter of law, on a straightforward reading of this provision in my submission, that was enough. Right. The second point, that is about the legislative scheme. Now, the general purpose of the legislative scheme is twofold. First, to prevent and discourage illegal employment. And second, to require and encourage employers to carry out necessary checks to ensure that they offer employment to only those who are allowed to work. Now, this in turn not only protects the local labor market, but also serves an important disincentive to those who are minded to come to the UK legally for economic reasons. It sends out a message that finding employment in the UK in breach of immigration laws is going to be incredibly difficult. So the scheme is a vital tool in administration of immigration control. And the scheme, in my submission, would be undermined if an employer who employs someone with no right to work without an excuse, if that employer is able to sidestep the obligation and avoid relevant consequences on the basis of a technicality. The technicality of the kind highlighted by Miller and Friend, namely the notice does not expressly identify the relevant limb of subsection 1 that is said to be breached. Now, Parliament has legislated to ensure that a technicality of this kind does not undermine the statutory purpose. That is why it enacted Section 17 of this Act. Now, you have that provision at page 8 of the authorities bundle.
Yeah.
Now, if you look at subsection 1, my lords will see that that subsection exclusively identifies the grounds on which a person may bring an appeal. That the employer is not liable to the penalty, there is a statutory excuse, or the amount is too high. Now, that provision excludes the possibility of an employer raising a technical objection on an appeal. Now, the provision does not say that the employer may bring an appeal to the county court on the basis that the relevant subsection is not identified or the reasons given in the notice are not clear or inadequate. The submission that Miller and Friend has made this morning.
Well, I wonder if that's right. Surely would be a ground of appeal for an employer to say, I'm not liable for a civil penalty because you never served me with a valid notice. Would that not be a possible ground of appeal?
Well, yes, that in principle would fall under section
A.
1A, yes.
yeah.
I have no difficulty with that. But what an employer cannot do is to bring an appeal on the ground that the reasons given in the notice are inadequate or they are not clear. So my lords have heard a submission from Miller and Friend this morning that the reasons given in the notice were not clear. It wasn't clear as to what the notice was saying. So there is no right of appeal on a sort of technical ground as to failure to give adequate reasons. But if you then look at subsection 3, you will see that the appeal is a rehearing of the Secretary of State's decision. The Court on Appeal may take into account new matters, can consider fresh evidence, and any other matter which the Court thinks is relevant, including the matters which the Secretary of State was unaware of. So therefore, if a penalty notice had issued on a mistaken belief that it's limb 3 that applies, not this case, but assume for a second that there is a notice that wrongly identifies the relevant limb. But by the time of appeals, it transpires that that isn't the correct limb, but a different limb applies. The county court is perfectly entitled to take the fresh evidence, fresh matter into account and decide for itself as to whether or not there should be a penalty. So the appellant's interpretation, if accepted, would not allow such mistakes to be resolved at the rehearing. Well, despite the fact that it's clearly possible under the legislation and that it could lead to a just outcome. The respondent on Milan Friend's interpretation would have to reissue the notice. There would then be an opportunity to submit objections, and the appeal process will start again. This is precisely what, in my respectful submission, the scheme seeks to discourage. So looking at the scheme as a whole, in my respectful submission, the case is inconsistent with it. Finally, the authority. Now, there are two authorities that I will take my lords to, and I'll take my lords to those authorities not to make the synergy point that is made in the supplementary skeleton argument, but in support of a point that the judge made in the judgment below. So can I just take you first to paragraph 41 of the judge's judgment, and we'll then take you to the two authorities. So if you look at page 54 of the bundle, and first, if you look at paragraph 41, you'll see that the Secretary of State's case at the hearing was that it is Roman 2 that applied. This is the last sentence of paragraph 40.
40, yeah.
Yes, and then paragraph 41, the judge says that, well, there is no prejudice to the appellant in allowing the respondent to rely on the notice, and the judge then gave reasons as to why it would not be unjust to allow the matter to proceed.
Although if you're right about 17.1, he didn't need to do that.
Yeah.
Sorry, 17.3. You didn't need to do that because you say you can rely on an appeal on any matters, including matters of which the Secretary of State was unaware at the time of the original notice.
Yes, but what
It says expressly, effectively, this overrides rules of court.
Yes, yes. But that is the point that the judge made about prejudice, and I felt it appropriate to show this paragraph, given one submission that Milan Friend made this morning, as to a possible prejudice. There is a finding that there was no prejudice, and there is no appeal from it. Now, two authorities that may assist you, Lords, in relation to that particular point. The first is J.N. Cameroon. This is tab 4 of the authorities bundle, page 59. My lords, if you go to page 62 of the bundle, you'll see that at paragraph 8, this is the judgment of Lord Justice Richards.
Yeah.
The relevant legislation is identified, and you'll see that the notice of an immigration decision was required to include the state or territory to which it was proposed to remove the person concerned. This is the quotation in paragraph 8. B, Roman 2, shall state the country or territory to which it is proposed to remove the person. Now, there was a failure in that case to comply with that condition, and therefore the notice was defective.
This is a sonergy case, isn't it? Isn't that on the basis on which the court decides the case?
So two alternative points that were made. The first was the synergy point. I'm not making that point.
No.
The only point, my lord, that I will make is one that is made at paragraph 27, the first part of the paragraph 27, not the second part. So what Lord Justice Richards said that, well, despite what the notice said, the position was clear.
Yeah.
And it had no impact on the appellant's ability to present the appeal. That ability was not impaired by the failure to state the destination in the notice. There is then the synergy point. applies here in my submission with full force. By the time of the hearing, the position was absolutely clear. There wasn't any prejudice to the appellant. And the failure to specify which limb of Section 15(1) apply did not impair the appellant's ability to pursue the appeal effectively.
Right.
The second authority, Lords, is the judgment in Huang. This is tab 6 of the authorities bundle. Tab 6 of the authorities bundle. If you go to page 85, you'll see paragraph 40 of the judgment. This is where section 94 of the Nationality, Immigration and Asylum Act 2002 is cited. You'll see that it has 3 subsections, 1A and 2. That was a case where the notice of decision referred to subsection 1A, but the correct subsection that was applicable was subsection 2. So the notice was defective, it cited the wrong statutory provision. And that triggered the challenge on the basis that the notice was invalid or unlawful. It was common ground at the hearing that the correct subsection was not one that was referred to in the notice. The judge makes a point about synergy, not the point that I make, but can I respectfully take you to page 90 of the bundle and ask you respectfully to look at paragraph 58, second sentence, line 3. It is inconceivable that the claimant could, by this defective documentation, have been misled into believing that she had a sustainable in-country right of appeal, when the entire reading of the reasons letter made it plain that the claim was unfounded. So two points that arise. The first is that you've got to look at the decision, the notice as a whole. And secondly, if the position is clear, then that is the end of the matter. So the submission that my learned friend makes is inconsistent with the authority too. So unless I can assist you any further, for these reasons, I respectfully invite you to uphold the decision made below and dismiss the appeal.
Thank you, Mr. Malik. Mr. Mohammed, do you wish to reply?
Very, very briefly.
Yes.
If I may, Your Lord, I'm just looking at section 17 of the 2006 Act.
Yeah.
Well, then if I refer you to that, in particular 17.3.
Hang on.
Page 62 of the bundle, I believe.
Yeah, section 17, particularly section which?
Subsection 3.
Yeah.
It says the an appeal shall be a rehearing of the Secretary of State's decision to impose the penalty of in my respectful submission, that's the point of today's hearing, isn't it? Is to say that was a valid decision made in accordance with section 15. You haven't stated why you've given the penalty notice.
Yeah.
So it doesn't go any further than that in my respectful submission. There's no assistance to the respondent in that regard. And then finally, my learned friend refers you to cases where effectively defective notices were seeking to override the objective of the legislation. No such situation arises here because the respondent can simply reissue the penalty notice. By being able to reissue without any prejudice whatsoever to them, that overcomes any of those arguments that were made. You're not going to defeat the legislation, it will just come back in the correct form. If I can put it that way, then the notice will come back in the correct form. Just those 2 points.
Right. Well, thank you both very much. Now, don't leave the courtroom. We will rise for a few minutes just to see where we're going from here.
I don't actually seem to sometimes I can't see what's on the screen.
Court rise and open.
Thank you very much for your very interesting submissions. We will dismiss the appeal for reasons to be given later in writing. You will get a judgment in the usual way. It's your opportunity to correct our English, but not our reasoning. And we would hope that in the light of the judgments, you will be able to agree a form of order. If you can't agree a form of order, then please make written submissions and we'll make the order appropriate.
I'm very grateful. In that case, I will say nothing about costs at this stage. I'll seek to agree in order with the letter.
Yes, well, I mean, in principle, there's not much that Mr. Mohammed can say to resist an application of costs. There may be a squabble about how much, but that can be dealt with later.
Grateful, thank you.
Thank you very much.